That trial's been going on for a while. Eric Molitor and William and Michael Null faces charges of providing material support for an act of terrorism and felony firearm. Jamie White is a Michigan trial attorney who has experiences in these high-profile cases and joins us now on Good Day Northern Michigan. Thank you for joining us, Jamie.
My pleasure.
Yeah, Jamie, give us your take on this, because this was kind of the target date for the trial to end. So, we would expect to have heard, this going to the jury today. Obviously, it's taking a little longer with Eric Molitor's testimony that stretched Thursday and Friday as well. But give us your take on where things stand right now today.
Well, I don't think anybody reasonably expected Mr. Molitor to testify. So the fact that it might take a little bit longer, I think, factors that into the equation. His testimony was pretty extraordinary in the sense where he really admitted his wrongdoing in this matter and doesn't really leave the jury much choice. The statute doesn't say that you only materially provided a little bit of assistance. It just says that you materially provide. And we know that he brought a gun to the scene. There was a slow motion picture taken in the governor's house. And in fact, he was the one who located her residence in northern Michigan. So, that is the classic definition of material assistance. We do have an affirmative defense to these sorts of cases that he seemed to be dancing around, and that is a withdrawal from the conspiracy before it occurs. And that takes more than just standing in the doorway at a bank robbery and not going in. It really requires an overt act, something that nobody can dispute, that you no longer were a part of this, whether that's telling authorities what happened before it occurred or, running out of the car. His testimony was that he was scared and therefore went along with the plot. And I just don't think that carries water, at least not from a legal point of view.
Well, I think a couple of questions on that note. I think, as you said, we were not expecting him to testify, so I'm curious about just the strategy from that standpoint that you think. And one thing that he mentioned, I believe, in his testimony last week was that he was preparing to go to police, that he was trying to gather evidence and was about to go to the police right before he was arrested. I don't know, again, if that, as in your words, carries a lot of water, but that may be strategic from the defense point of view.
Yeah, I do think so. And to your first question, I personally think it was a big mistake to have Mr. Molitor testify. The federal defendants who were acquitted, they were acquitted based on attacking the credibility of the FBI and, and other cooperating witnesses. And, sometimes that evidence can be powerful when a jury is deciding whether or not someone is guilty beyond a reasonable doubt. But Mr. Molitor admitted to all of the behavior. And to your second point, is suggesting that in his mind, he was ready to get in the way of the conspiracy and contact the authorities. But without some evidence of that, it's like robbing the bank and saying, I was going to return the money.
And he did admit to surveilling Whitmer's house, right? So there are these things where you feel like he is trying to distance himself, but he's going to have kind of a hard time when he has things like that pop up.
I think so. I think I would say he's the most sympathetic figure of the three, based on his testimony and based on other evidence that has come out over the course of the last couple of weeks. But there's not going to be a jury instruction that says if you feel sorry for him or you think that maybe he's a good guy and made a bad decision, therefore you can set him free. It's going to be very specific, and the elements are going to read like this. Did you in fact aid and abet a conspiracy to kidnap Gretchen Whitmer? And did you know at the time what you were doing? I guess that's the second prong of his defense, is he didn't know it was the governor's house, despite the fact that he looked up the address and he conducted the video surveillance. So they don't really have much to work with, but I do think putting Mr. Molitor on the stand was a mistake.
What about his strategy of using that he was afraid of the other two and that he was doing some of these things because of fear?
That's a great question. It's probably the most empathetic point of view that a jury could take with him, but it's sort of a hybrid between, like a Patty Hearst kind of defense. And, oftentimes we'll see people who are dragged into a bank against their will to hand somebody a note because their family has been abducted, something of that nature, where true fear has overcome your ability to make rational decisions. And here, I just haven't heard enough in my mind that a juror could find that he was actually scared, other than his testimony. His behavior is to the contrary. Stranger things have happened. And I do think, to your question, that's probably the strongest piece to get the jury's heartstrings pulled.
Jamie, let me just ask you two more questions here before we wrap up with you. One is just the breakdown, if you would explain for us the two different defenses here for the Null brothers and for Eric Molitor. So we've got a chance for the Null brothers to wrap up their closing arguments or any final witnesses, and then closing arguments. Essentially, we've got one prosecution and two separate defenses. Am I understanding that right?
That is correct. That is my understanding of how things will proceed. The jury is going to get conflicting arguments in the closing. And to your earlier point, to some degree, Mr. Molitor is suggesting that he was coerced or was in fear for his safety, his life, I suppose, if he were not to cooperate. And that clearly puts him at odds with the other two defendants. And, we have a rule that you're supposed to be able to cross-examine your co-defendants if, in fact, there becomes an adversarial position between the two. And I believe that's occurred at this point in time. It's too late for the defense or the prosecutor to raise that issue, but I do think it's going to make for interesting closings, because the defendants, to some degree, will be trying to cooperate. But I think if we're going to use Mr. Molitor's testimony as the evidence that will be in front of the jury, his attorney is going to have no choice but to argue that the other two people were culpable and that he was in fear and continued for that reason.
Am I also remembering correctly when we talked a couple of weeks back about whether or not they could bring up the fact that some of these other individuals had been found not guilty, that wasn't allowed to be brought up? And if that's the case, is that still something that could either be even mentioned in a closing statement, or something that a juror could take with them? Hey, a couple of guys have already gotten off from this. Maybe not everyone is guilty. How do you distinguish who's guilty and who's not when we're in completely separate trials?
So being completely separate trials is the basis for why that is completely irrelevant. And even if they were in the same trial, let's just say somebody was dismissed during the course of a trial, or somebody pled guilty during the course of a trial, or for whatever reason was excused from the trial, even in the same trial, the jury would not have access as to why that defendant is no longer at the table. So add that to the fact that the first set of acquittals was a federal court, and there was no possibility, as we discussed a few weeks ago, of this other extra collateral evidence coming in of other co-conspirators' guilt or innocence. This prosecutor had the option to try the people in his jurisdiction, and their behavior and their behavior alone is, for the most part, notwithstanding a couple of exceptions, the only thing that applies.
Well, Jamie, really appreciate you giving us your input on this. As always, I also can't help but notice the MSU football behind you, and maybe in the weeks ahead we'll be talking Mel Tucker with you at some point. We addressed that before you came on today, but thanks so much for your insight, and we'll check back with you again here in the near future. Yeah, Jamie White with White Law PLLC. Thank you so much for being with us.
Thanks for having me. Take care.
All right. You